The question is that the document be noted, and I call the member for Warringah.
Thank you, Mr Deputy Speaker. I commend to the House the second interim report tabled on behalf of the Joint Select Committee on Australia's family law system, of which I was a member. I'd also like to take this opportunity to thank my colleagues and fellow parliamentarians for the work on this inquiry, which was quite lengthy over a period of time with a substantial number of submissions. But also we had robust discussions that I think ultimately can really be seen through this report. But I'd also like to thank the Secretariat, who really had to do a lot of work in light of the volume of submission and the highly emotional nature in many instances of the issues being the subject of submissions. But in commending to the House this second interim report, I also must call on the government to actually act on the report. Don't let it sit on the shelf, like so many similar reports that have come before it. So we have to actually note this. It should be noted there's been 67 different inquiries into the Family Law Act since it came into effect in January 1976. And unfortunately, there is a history of successive inquiries identifying similar systemic problems with our family law system and successive governments being unwilling or unable to make the necessary changes. So for the people of Australia who are going through these highly distressing situations, out of respect for them, I do call on the government to enact the changes and the recommendations that are called for. The most recent of these inquiries was in fact the Australian Law Reform Commission report, which was handed down in March 2019, entitled Family Law for the Future, an inquiry into the family law system. That report contained 60 different recommendations on how to improve the system, and ironically, our inquiry looked at many of them and arrived at similar conclusions. So sadly, almost 2 years on from that report being tabled, the government is yet to respond. So just recently, in Senate estimates, it was revealed that the Attorney-General has had the government's response on his desk 17 months ago, but it is yet to see the light of day. So I do use this opportunity to again call on the government to publicly respond to the ALRC report and to urgently implement the full list of recommendations. Mr Deputy Speaker, the reality of modern society, sadly, is that 40% of marriages end in divorce. Whilst many of those separations are conducted fairly and amicably, there are still many Australians who rely on the family law system to settle their divorce and resolve disputes over property and custody of children. Most of us know someone who has gone through the family law courts or who have experienced it firsthand themselves. I should say myself have been through the system, and my husband has also been through the system. So I do know firsthand the experience from a personal point of view of the family court system, but also having practiced in the jurisdiction as a family law barrister for some 10 years before coming to this place. To various degrees, the process can be adversarial, confrontational, emotionally unsettling, financially crippling, and life-changing. So it's for that reason that it is imperative that our family law system needs to be not only functional, but it must be fair and well-funded. And it's for that reason that this inquiry and its recommendations are so important. Over the course of the inquiry, we received more than 1,600 submissions, the majority from individuals detailing their very personal cases and experiences, and another 169 submissions from organisations, academics and other professionals. Despite the various challenges of COVID-19 throughout 2020, the committee held 12 public hearings and 13 in-camera hearings. So I should say it was a very thorough hearing of the issue. At this stage, I would also like to thank all the people who participated to the inquiry and who made submissions. They often aired issues that were deeply personal and deeply emotional, but it was often in the hope that others would have a better experience, that they shared their experience. It was vitally important that we hear from those who have had first-hand experience with the system and a desire to improve it. The terms of reference for the inquiry were far-ranging, and on the whole, I feel they are addressed in this interim report and are consistent with my own experience, I should say, as a family law barrister. There were a number of key issues identified through this inquiry: the costs associated with the family law system, the adversarial nature of the family law courts, and whether we should move towards a more inquisitorial model, the issue of distressing delays in the court system, and that was a recurrent complaint, the amount of time it took for highly sensitive issues to parties to come before a judicial officer for determination. The role of family consultants, expert witnesses and independent children's lawyer, the weight that is given to their opinion and advice, maybe the inconsistent approach or experiences different witnesses experience in their interactions with family consultants and independent children's lawyers. Enforcement of family law orders was a real question around what happens after you leave the courtroom and how are orders once made in fact put into practice, and in fact are they keeping families and children safe and delivering their stated purpose, especially when it comes to parenting, to ensure that the decisions and arrangements in the best interests of the children are in fact continuing. And we, of course, heard also a lot around domestic family law, domestic violence, and that interaction between the family law and domestic violence jurisdictions, and when it came to local courts interacting with the family court system. The committee arrived at 29 recommendations. I won't go into all of them in detail, but I would encourage everyone interested in this area to read the report. But broadly speaking, they covered the funding and expansion of a number of pilot programs providing support and mediation to parties going through family separation. Resourcing of the Family Court of Australia and the Federal Circuit Court, of course, these now having been changed since the merger legislation having passed this place. The harmonisation of processes between the Family Court and the Federal Circuit Court, again, these slightly outdated now. The levelling of certain costs and fees in family law proceedings, mandatory accreditation, standards and monitoring processes for those involved in family law proceedings, as well as professional development opportunities. It's important that we recognise the stress that professionals are under that work in this system, especially judicial officers, and the approaches to make family law courts less adversarial, amplification of the voice of children in proceedings where appropriate, and the issue of perjury and wilfully misleading the court. Issues of domestic and family violence and the role of police, family violence orders and personal protection orders, which include looking at how to deal with the rare instances of, well, we dealt with a number of issues in relation to allegations of false complaints. And this is where the delay in the timeliness resolution of dispute really came to the fore. Improved information sharing between various government agencies and various jurisdictions, increased funding for legal aid and community legal centres, and a review of policies to allow for funding of both parties in appropriate circumstances. Amending the Family Law Act 1975 to address a misunderstanding about shared parental responsibility, clarify the requirements on independent children's lawyers, and to address the issue of disclosure duties regarding financial circumstances. In general, I agree with the majority of the recommendations. In closing, there are two issues I want to discuss: the number of judges in the family law system and the recent merger of the Family Law Court of Australia with the Federal Circuit Court of Australia. As of 6 November 2020, 2 in 3 Federal Circuit Court judges had more than 300 matters on their dockets. 27 judges have more than 400 cases, and 5 judges more than 500, and 1 more than 659 cases. In the Family Court, 2/3 of judges have more than 300 cases in their dockets, and 5 judges have more than 500 cases. To put this into perspective, this just shows there is a chronic under-resourcing of the court and an inability to deal in a timely manner with issues. So whilst this inquiry has come with very important recommendations, they will be for nothing if the courts are not adequately resourced with judicial officers to hear the matters. And the delays are real and have a huge emotional impact on the parties participating. Many people that participated with the inquiry urged the government to be mindful of the issues of domestic violence and the interrelation with the family law court system, and I encourage all of those to contact and get help from the various services. Thank you.